Welcome to this deep dive. Today, we're taking a close look at a really important Supreme Court case, Colbertson v. Berryhill.
That's right. And understanding this one is pretty crucial if you want to get how attorney fees work in Social Security disability claims.
Especially, when a claimant needs help both with the agency, the Social Security Administration, and then maybe later in court.
Exactly. The big question, the heart of the matter really, was about this 25% cap on attorney fees. Everyone agrees it applies to fees from past due benefits for court representation under Section 406B. But does that cap only cover the court fees? Or does it cap the total amount an attorney can get for work at both the agency and court levels?
So the whole fee picture, not just the court slice.
Precisely. And the oral arguments we're about to unpack, they show a really fascinating debate. It's all about interpreting the statute, its history, what Congress meant, and crucially, the practical effects on claimants and their lawyers.
Okay, let's start with the petitioner, Mr. Colbertson. What was their main line of argument?
Well, Colbertson's attorney argued pretty strongly that the 25% cap in Section 406B applies only to the fees for the work done specifically before the court.
Just the court part.
Yeah. They really zeroed in on the specific words in the law. 42 U.S.C. Section 406B. It refers to such representation.
Okay.
And the statute clarifies that such representation means representation before the court. So they're saying, look, the text is clear. It limits court fees.
Makes sense textually. Did they bring up the agency fees part?
They did. They pointed out that Section 406A, a different part of the law, has its own separate way of handling fees for work done just before the agency, the SSA.
So two separate systems, basically.
That was their argument. They said, look, Congress knows how to create an aggregate cap, a total limit covering everything if it wants to.
Ah, okay. They have examples.
Yeah, they cited another part, 406A2, which explicitly uses the term in the aggregate. And they also mentioned the Equal Access to Justice Act, EAJA,
Right, EAJA fees.
Where Congress set up specific rules about offsets and limits. The point was, if Congress wanted a total 25% cap in 406B covering both agency and court fees, they would have used clear language like that. They didn't here.
So the silence is meaningful in their view.
Exactly. They also brought up a prior Supreme Court case, Gisbrecht.
Gisbrecht, right. How did that fit in?
Well, Gisbrecht dealt with how to determine reasonable fees. And the petitioner argued the decision implicitly treated agency work and court work as distinct things for fee purposes. So Gisbrecht supports keeping them separate.
Got it. Now, I know Justice Ginsburg asked about an overall limit on the claimant's recovery. What was the answer there?
The petitioner's lawyer acknowledged that, yes, the agency has this practice of withholding up to 25% of the past due benefits, and that withholding can cover both agency and court fees.
Okay.
But they stressed that this withholding practice itself wasn't what was being legally challenged in this case. It's a separate administrative thing.
And Justice Sotomayor, she seemed worried about attorneys maybe double dipping or trying to collect extra fees directly from the client.
Yeah, that concern came up. The petitioner's side suggested that's probably pretty rare.
Why rare?
Well, mainly because many disability claimants are, frankly, judgment-proof. They don't have extra funds to pay lawyers directly.
Makes sense.
And they also mentioned again that EAJA awards could potentially cover the agency-level fees anyway, reducing the need to go after the client for more money.
Okay. Then Justice Breyer asked a very direct question, didn't he? About the possibility of a 50% total fee.
He did. He asked, could an attorney, under the petitioner's reading, potentially be authorized for up to 25% for agency work and another 25% for court work, totaling 50% of the past due benefits?
And the answer?
The petitioner's counsel said yes, that is theoretically possible under their interpretation.
Wow.
If, and this is important, if the judge finds the court fee reasonable under the circumstances, and assuming there wasn't a big EAJA award offsetting things.
That 50% number sounds high. What was the justification for allowing that possibility?
The core argument was about incentives. They argued that imposing an aggregate 25% cap for all work would actually discourage attorneys.
How so?
Because if the agency work already used up most or all of that 25% from the past due benefits, a lawyer might look at a case needing court representation, which is often more work, and think, well, I might not get paid much or anything for this court effort.
Ah, so it could hurt the claimant's ability to get representation in court later on.
That was the concern they raised, a potential access to justice issue.
Okay, that lays out the petitioner's position really clearly. Let's flip to the respondent, the acting commissioner of Social Security. the government's position.
Right, so the government lawyer actually argued for reversing the lower court's decision, which had favored the petitioner.
Wait, reversing? So they disagreed with the petitioner?
Well, it's a bit nuanced. On the narrow question of interpreting Section 406b(1)(a) itself, the government actually agreed with the petitioner.
Agreed.
They agreed that, yes, that specific provision, 406b, governs fees only for court representation, and its 25% cap likewise applies only to those court fees.
Okay, so they agree on the text of 406b. Where's the disagreement then?
The disagreement comes in how it all fits together. The government focused on the interplay between 406b for court fees, where fee certification is permissive, and 406a for agency fees, where the 25% certification for payment from past due benefits is mandatory.
Mandatory versus permissive, okay.
And the government explained that the agency's long-standing interpretation and practice, until fairly recently, had been to cap the total payout from the withheld funds at 25%.
So even though 406b technically only limits court fees, the agency's payment mechanism effectively created an overall 25% ceiling from the withheld funds.
That's the gist of their position on the practical application. They see it as an integrated system where that 25% withholding acts as the primary governor.
Interesting. Did they address the concern about collecting fees directly from clients?
They did, but from a different angle. They pointed out that some non-attorney representatives who work at the agency level aren't always eligible for direct payment from the past due benefits under a different section, 406e, meaning those reps have to collect directly from the client sometimes. The government argued this shows Congress knew direct collection might happen and didn't prohibit it across the board.
What about Justice Sotomayor's worry about garnishing future benefits?
The government drew a distinction. They said, generally, you can't garnish future benefits for these attorney fees. But if the agency made a mistake and didn't withhold the proper amount from the past due benefits initially.
Like an under withholding.
Right. Then recovering that specific previously awarded but uncollected amount is different. It's more like recouping an erroneous payment, not garnishing future income.
Okay. Did the government acknowledge the potential for fees to exceed 25% in total under their reading of 406b?
They conceded the textual point, yes. They acknowledged that district courts have this reasonableness review for court fees, and maybe total fees hitting 50% is rare.
But
they argue those practical points don't change the statute's meaning. However, they did suggest there might be specific situations like maybe an overpayment case, or one with a late disability onset date resulting in smaller past due benefits.
Right, where the 25% pool is small.
Exactly. In those cases, they suggested maybe combined fees over 25% could be reasonable and necessary to make sure the claimant actually gets represented at both levels.
Okay. And what about appeals if a case goes beyond the district court?
The government argued that the 25% cap in 406b should apply to all court proceedings related to the claim, including appeals court work.
To prevent fees from just piling up indefinitely through the court system?
That seemed to be the concern, yeah. Avoiding potentially exorbitant fees. They suggested a normal scenario should probably end up with combined fees, agency, and all court work not exceeding 50% anyway.
Okay, government view covered. Now, there was also an Amicus Curiae, right? Court appointed?
Yes, an amicus appointed by the court to argue in support of the judgment below meaning, to argue for the aggregate 25% cap.
So, arguing against both the petitioner and, on the key interpretive point, the government's current position.
Exactly. The amicus took a broader view. They argue the best way to read Section 406, looking at its whole history, all the amendments over the years, and the agency's interpretation for decades.
The long-standing one.
Right. The best reading is a single aggregate 25% cap, covering both agency and court fees drawn from the past due benefits.
What was their reasoning for that holistic view?
They talked about the plausible reading of the statute as a whole. They highlighted how the 25% figure pops up repeatedly and argued the main purpose has always been to protect claimants' benefits from excessive fees.
And the agency's system.
They stressed that the whole framework the agency built for handling fee payments was based around withholding that single 25% pot of money.
So history and structure point to one cap.
That was the argument. They said a 25% aggregate cap balances Congress's goals, regulating fees fairly, but also protecting vulnerable people. They even mentioned the original concerns back in 1965 about unregulated high court fees that led to some of these rules in the first place.
What about the incentive argument? Justice Gorsuch raised that about making sure lawyers take complex cases.
The amicus pushed back on that. They said, look, there's really no solid evidence that the aggregate 25% cap has actually stopped people from getting lawyers.
They think there are enough lawyers doing this work.
Yeah, they pointed to what they called a healthy Social Security bar. Plenty of lawyers specializing in this. And again, they mentioned EAJA fees is another way attorneys can get paid, especially for the agency work.
Okay. And Justice Breyer's hypothetical about large future benefits but small past due benefits.
The amicus kept the focus squarely on the past due benefits. They argued the fee under Section 406 is calculated based on the work done to get those past due benefits. Future benefits aren't really part of that specific fee calculation.
And if an attorney thinks they're owed more than the 25% withheld, Justice Sotomayor's question again.
The amicus suggested the attorney's recourse would likely be against the past due benefits the client already received, not by trying to claim future benefit payments.
How did the amicus handle the petitioner's big point about such representation in 406B?
They offered a different spin. They argued that such representation, meaning the successful court representation, actually supports a 25% cap for that court success.
How so?
Because, they reasoned, getting agency representation first is almost always required to even get to court. It's all part of one process leading to the past due benefits. And since it all comes from one pot of withheld money,
it points back to an aggregate limit.
That was their view. They also quite pointedly mentioned the government's own past arguments.
Oh.
Yeah, they cited a brief from decades ago, the Dawson case, where the government itself apparently argued strongly that allowing more than 25% total would be against Congress's intent, emphasizing claimant vulnerability.
Wow, pulling out the old arguments. So summing up the key disagreements.
It really boils down to, what does such representation in 406B truly mean in context? Is the 406B cap totally separate from 406A, or are they linked? What are the real-world effects on attorneys taking cases and on claimants' finances? And how much weight should the agency's historical interpretation carry?
Those practical implications seem huge. Access to lawyers versus protecting benefits.
Definitely. The justices seemed very tuned into that tension. It's amazing how those two little words, such representation, became the pivot point for this whole debate about balancing attorney compensation and claimant protection.
It really shows how interpreting seemingly simple legal texts can be incredibly complex. And the downstream effects are significant for real people. You know, the arguments about congressional intent, the structure of the law, the practical realities. It was a lot to untangle.
Absolutely. That core conflict, a strict 25% cap just for court fees versus an aggregate cap for everything, has profound consequences.
Makes you think, doesn't it? If the petitioner won, allowing potentially higher total fees, would that really improve representation or just increase costs? And if the amicus view prevailed with the strict aggregate cap, is that always enough to compensate lawyers fairly for potentially years of work across different levels? It's that tricky balance between legal interpretation and the human impact.
Definitely food for thought.
Yeah.
Which brings us nicely to our 10th chair segment. Time to put on the imaginary robe.
All right, Justice Expert's imaginary name, the floor is yours. How would you have decided Colbertson?
Okay, 10th chair hat on. This was a tough one, honestly. The textual argument from the petitioner, focusing just on 406B, is strong in isolation. Such representation does seem to point just to court work. But I find myself persuaded more by the Amicus Curiae's broader view, looking at the whole statute, its history and purpose. Section 406 is fundamentally about regulating fees to protect claimants. The repeated references to 25% and the agency's long-standing practice, even if they recently changed their litigation position, suggest an understanding of an overall limit tied to that 25% withholding from past due benefits.
So the context matters more than just the isolated text of 406B.
For me, yes. Allowing court fees to potentially stack entirely on top of agency fees, possibly consuming up to 50% of the past due benefits intended for the claimant, seems to run counter to that protective purpose. Congress created this system, including the direct payment mechanism from withheld benefits, seemingly with that 25% figure as a central regulating principle.
What about the incentive for lawyers?
That's a valid concern, no doubt. We need lawyers willing to take these cases. But the amicus made good points. There isn't strong evidence of a widespread problem under the aggregate cap interpretation. There is a Social Security bar, and EAJA fees provide another avenue for compensation, particularly for fighting the government at the agency level.
So balancing the factors.
Balancing the factors, I think the 25% aggregate cap, while perhaps imperfect, better reflects the overall legislative scheme and purpose. It prioritizes preserving the bulk of the past due benefits for the vulnerable claimant, which seems to have been a primary congressional concern from the beginning. It treats the agency and court phases as part of a single, albeit multi-stage, process for securing benefits, with fees ultimately drawn from the single pot of funds generated by that success. So I'd affirm the lower court decision that applied the aggregate cap.